Well, good afternoon and welcome to the inaugural panel of the new Transitional Justice in the USA Speaker Series. I am Lisa Laplante. I'm a professor at New England Law School in Boston. I also direct the Center for International Law and Policy. And it's my great pleasure to host and moderate this first panel, as well as launch this new speaker series. I want to provide a little bit of background about how this series began. It grew out of a discussion last summer among a group of transitional justice scholars and practitioners who wanted to explore, understand, and support what was a clear, evident movement, national movement in the USA, driven by local activists and advocates and government officials. And they were designing reparation programs and truth programs and institutional reform and justice for racial violence and systemic racial injustice in the United States. Now, many of us recognize that these mechanisms are understood within our field as transitional justice, and that this framework has led to redress movements around the world. But until recently, we hadn't really been talking about it as it relates to the United States. So since that initial discussion, this network has actually grown quite rapidly, and this series is now co-sponsored by 30 academic centers, departments, programs, as well as civil society groups, all of which span the United States. So we were working very hard to make sure that we had representation in all corners of the state. You can see the list of co-sponsors on the series website page. And that list continues to grow. We actually got a co-sponsor today. And if your institution is interested in becoming involved, you can learn about how to do that on the website. I also want to let you know that we've already posted our next panel for March 24th, which is the International Day of Truth. It is how do we build collaborative models for a transitional justice process? And that is from 4 to 6:30. So you can already register for that, and hopefully we'll see many of you there as well. So I want to start by just thanking all of the support from the co-sponsors. It's truly been a collaborative effort, and it can't happen without that collaboration. So I very much appreciate that support. I believe the support arises out of the recognition of the importance of this topic. And this speaker series really is hoping to raise national awareness of transitional justice initiatives in the US, which are cropping up on a regular basis. We are trying to keep track, and as of now, there's between 35 and 40 that have been created since last summer, which is pretty remarkable. They are at the municipal, the state, the federal level. So really in all different states and all different areas, and they cover a lot of different topics. We hope to sustain this forum to encourage an open dialogue about the benefits, the accomplishments, and the challenges of this work. So to launch this speaker series, our first panel today, Comparative Lessons, What is Transitional Justice and How has it worked in other countries, will highlight the experiences of transitional justice processes in other nations to help understand how it has worked globally. But we also intend to dive into the question of if and how the transitional justice framework relates to the United States, whether international experiences are relevant to this work of truth, reparations, justice, international work, and what that might look like. We have a very distinguished panel of speakers, and I won't be looking at I won't be offering their specific bios, because you can find that on the website, and there's so much to say about each of them. So I encourage you to go look at that. But I do want to just share generally who they are and what they'll be talking about during this panel. So we're very fortunate to have Pablo de Greiff, Director of Transitional Justice Program and the Prevention Project at the Center for Human Rights and Global Justice at NYU School here today. He's a former, and he was the first UN Special Rapporteur on the promotion of truth, justice, reparations, and guarantees of non-recurrence. He will be starting us off offering a general framework for what transitional justice is. And then we will have to share about global experiences in the different mechanisms, starting off Igor Vetkovsky, who is now Senior Advisor on Reparations to the Global Survivors Fund, Eduardo Gonzalez, who's a research affiliate with the Mary Hawk Center for Reconciliation, also worked with the Peruvian Truth and Reconciliation Commission. Sarah Kasande, who heads the Office of the International Center for Transitional Justice in Uganda, and Yasmin Suka, who is the Executive Director of the Foundation for Human Rights in South Africa, and a former member of the South African Truth and Reconciliation Commission, as well as the Truth and Reconciliation Commission of Sierra Leone. We will conclude the panel discussion with Sally Avery Bermanzen, who is a professor emerita from Brooklyn College, CUNY, who was a participant in the Greensboro Truth and Reconciliation Commission in North Carolina, who will be reflecting on the experience of a US Truth Commission and how it engaged with these international experiences, to then open up a conversation about how does transitional justice work in the USA. I want to just hit a couple of logistical points for the audience. We have disabled the chat just for the panel portion of this presentation. It allows me to give some time indications for our panelists. You are encouraged to pose questions in the Q&A. We will have moderators helping to go through those. We have a lot of participants today, so unfortunately we probably won't get to every question, but we hope to get to some of the common questions. And then once we open up for dialogue, we will open up the chat for people to add comments. I'm not promising we'll be able to keep track of everything that's being said, but we will try to enable that. This is being recorded and it will be posted on the website as well for those who are not able to stay for the whole event. So to get us started, Pablo, if you could begin our conversation and help us generally frame what is transitional justice.
Thank you, Lisa. I would like to start by thanking you and the other organizers for the invitation and invitation to a great project for which I offer my congratulations. And also to express my sense of joy for sharing the panel with friends and colleagues, people from whom I have learned a lot and who have a very important experience. So I was asked to talk about the transitional justice framework in general. I hope the remarks will not be too cryptic. I think that the transitional justice is best understood as that set of initiatives that countries that have suffered violations and abuses of different kinds implement in order to try to cope with their legacies, with the legacies of those violations. Just recently, I read a wonderful sentence by David Blight, a very active historian in this debate, who says that a legacy is precisely that point where the past and the present meet. And I think that this is relevant to this conversation. In any case, there are different ways of explaining the history of the notion. John Elster, for example, takes us back to classical Greece. I think that it makes sense to think about the more recent origins of the notion in the initiatives that the Latin American countries of the Southern Cone implemented in order to deal with the legacies of the violations that took place during their dictatorships. And this also suggests that it was a notion that developed in practice, not as the unfurling of a pre-existing theory, nor as simply the implementation of pre-existing obligations. In fact, I would like to argue that transitional justice has made a huge contribution to the development of international obligations, and that it has accomplished that in a remarkably short period of time. In any case, out of those experiences in the Latin American Southern Cone, which traveled very rapidly to Central America, Central and Eastern Europe, South Africa, and after South Africa disseminated very rapidly all over the world, a sort of a canonical understanding of the term transitional justice, which was only used in the late 90s and early 20s. That is after Argentina and Chile were implementing the measures that came to be known as transitional justice. A canonical understanding of the notion developed, which argues that it has four fundamental components: a criminal justice component, a truth-seeking and truth-telling element, a reparations dimension, and a preventive dimension, which in the field is known under the awkward expression of guarantees of non-recurrence. This is not an exhaustive list, but it, for most people, forms the core of the notion. And again, I want to say that the field managed to consolidate itself in a very short period of time, comparatively speaking. That, for example, by 2004, the Secretary General of the United Nations published a report in which transitional justice is described in terms of these four elements. Furthermore, conceived as a holistic policy, that is, the four elements, criminal justice, reparations, truth, and guarantees of non-recurrence, are not seen simply as items in a menu from which countries can pick and choose, but rather as elements that ought to be implemented, if not simultaneously, at least eventually and comprehensively in relationship to one another. And that holistic understanding of transitional justice, I think, is the most common one. In the short period of time that the notion, this particular understanding of transitional justice has become current, I want to argue it has made different types of contributions. Some of them are cross-cutting. The first one is precisely to unpack the notion of justice. So compared to, for example, classical human rights work, which made very valiant and very valuable efforts to judicialize cases of violations, transitional justice always advocated for a plurality of measures. Not because it considered that there was anything wrong with criminal prosecutions, but because it had a broader understanding of redress that called also for truth, for reparations, and for preventive measures. Secondly, I think that transitional justice has made a huge contribution to what I call making victims visible. In all countries in which transitional justice has become an issue, even in countries that have implemented the measures weekly, victims have gained a role in the public sphere, which I think is very, very important, not just for the victims, but for society at large. Third, I think that transitional justice, although far from being perfect in this respect, has learned a lot about how to make its measures more gender sensitive and more inclusive. So increasingly, for example, mechanisms such as broad national consultations are becoming part of the tools of transitional justice. And then the second set of contributions is more specific. I think that transitional justice has contributed to giving content and life to the right to justice, for example, by teaching how to cope with the effects of amnesties, by giving an incentive for countries to develop prosecutorial strategies, by diversifying the venues where justice can be sought. So it is not just in theory, but in practice that transitional justice has contributed to giving content to a right which otherwise could have been aspirational. Similarly, with respect to truth, there is, as we know, no international convention on truth. The International Convention on the Protection Against Enforced Disappearance does mention the right to truth, but there is no convention on that right specifically. But nevertheless, various international documents have been developed and practice has been established that entrench the right to truth. And this is the point I want to stress, not just doctrinally, but in practice. So, for example, through mechanisms such as truth commissions, which perhaps is the mechanism that is most identified with the notion of transitional justice, but also through other truth-seeking mechanisms, such as commissions of inquiry, of which Yasmin and Sally have a great deal of experience. The same thing can be said about reparations. There is a long and distinguished history of interstate reparations, but it is really transitional justice that has given content to that right, particularly through the development of massive administrative reparation programs for individual victims in intrastate situations. And a similar argument can be made about guarantees of non-recurrence. Now, this is celebratory. Of course, there are lots of challenges, including the fact that transitional justice awakens expectations that cannot always be met, that as all fields that become formalized and become formalized rapidly, it has very deeply technocratic tendency. And perhaps most relevant for this discussion, and I will end up here, is what some organizational sociologists and economists call isomorphic mimicry, the tendency to think that the very same institutional forms work equally well in all circumstances, and therefore the turning of the fundamental question that we are trying to answer from what is the most effective way to giving life to the victims' rights to truth, justice, reparations, and guarantees of non-recurrence, to the more technocratic question of what's the best way of establishing a prosecutorial mechanism or a truth commission or a reparations program, leaving aside the non-technical, more political, and to some extent more normative dimensions of transitional justice work. And I want to say that in the US, not falling into the trap of isomorphic mimicry will be the clue from my perspective of whether this is useful or not. Thank you very much. I'll stop here.
Thank you so much, Pablo. That was a great ending to think about for our the tail end of our discussion, but to start us off. So Igor, you will be talking about the experience of reparations as it has worked within the transitional justice framework.
Well, thank you very much, Lisa. I hope you can hear me well. Mm-hmm. Yes. Well, thank you very much again, Lisa, and everyone else who was involved in this organization of this important event. You know, I mean, one can only say, you know, transitional justice in the US, yay, what's not to like it, you know. I mean, looking from a perspective of someone who has been involved on mostly on reparations, but also general transitional justice, I can say that this is probably the most exciting process that is happening at the moment, you know. And it was obviously, you know, overdue. And this is not because, you know, there was no attention to it or there was no interest. There was an obvious demand for transitional justice in the US, including reparations for quite some time. There has been numerous initiatives, obviously, in the past, ranging from Truth Commission, but also long-standing demand for instituting reparative measures, reparation programs for slavery and for other forms of racial discrimination throughout the history. So this is nothing new in principle. You know, the elements of the demands for transitional justice have been there for quite some time. And some of these, you know, elements can be traced back, you know, to the civil rights movement, can be traced back even further back in history, if you look to the period of the Reconstruction and so on and so. So the demands for transitional justice, including reparations, they have been in the US for quite some time. Whether the US case is comparable to other cases, or whether there is something to learn from other countries, absolutely yes. I think, it's good time, to think and consider this in the context of the perceived or real exceptionalism of the US. And I think, perhaps, we can consider, the United States as something exceptional only if they do a transitional justice in an exceptional way going forward. So hopefully, this will lead towards a process, which will be, as Pablo referred to, a holistic process where all the transitional justice elements will be considered in parallel and complementing to one another. I think that's very important. But speaking from experience from other countries, I think, there is a sort of a caution, that I have learned by working in other countries, and that's a caution not to link perhaps all the transitional justice mechanisms too tightly. It is good that there is a complementarity. It's good that there is a cohesion between, but it should not be in principle any sort of finish to start relationship between the different transitional justice mechanisms. Why I'm saying this is because there has been challenges in many countries where certain transitional justice mechanisms, such as reparations, for example, has been conditioned upon completion of other transitional justice mechanisms. So there is no sequencing basically in transitional justice. And when countries have embarked on such an approach where it is sequenced, you first have a criminal justice, then you have a truth-seeking commission, then you have reparations, and everything else, it's pushed to the guarantees for non-repetition and reform, then there is a challenge, because some of the transitional justice mechanisms, particularly criminal justice, they tend to be very, very political, and they tend to consume the entire energy of the process, and then there is very little left to move the process forward toward truth and reconciliation or toward reparations and so and so. One such an example is the country, my former country where I come from, which is the former Yugoslavia. And as everyone who is familiar with the issues of transitional justice and the history of transitional justice in former Yugoslavia, it will remember that the entire energy of the process was consumed by the criminal justice process, by the establishment of the ICTY and by the national also war trials that were happening in different countries. So there is a very little energy actually left for any Truth and Reconciliation Commission. Never happened, it's not there, it's unlikely to happen so many years after. The same could be said for reparations. There was never really an attempt to do reparations. So in other cases, there has been similar challenge, where the transitional justice is perceived as a compact with all the elements, that needs to be pushed in the same time. And some of them are challenging. And Sri Lanka was mentioned here, and I think, in Sri Lanka, that has been a great debacle about what happened in Sri Lanka. There was a really ambitious transitional justice project, but then there was not sufficient buy-in because it was perceived as a one-sided. The process was too much perhaps perceived as a criminal justice process, and so and so. So that put sort of, not only that it put the transitional justice process in Sri Lanka on hold, it's actually influenced the politics of the country. So we have the situation that we have now. So, one caution would be so not, to have all the transitional justice processes complementing each other, but not necessarily depending on each other. I personally think that in US, this is not a problem and this is not a danger, because there has been already, some of the processes are already advanced, obviously in parallel. So there has been truth commissions coming up in different locations, pretty much decentralized, which is another issue that I will refer to it a little bit later. There has been also a long demand for reparations. And just last week, there was a congressional hearing on the HR 40, which is basically, a study proposed by more than 130, I believe, members of the House, who proposed, to have a study on reparation to determine, what would be the pathway and the way forward, So obviously there is a process going on, So there are all these parallel processes that are happening. That is very good, both in terms of seeking truth, but also in terms of reparation. So there is no great danger in terms of, the process being, sort of blocked because of this perceived compact of transitional justice. Now, apart from the sequencing, when it comes to international experience on transitional justice, the next big challenge, and I'm focusing on the challenges mostly, is determining the scope of the reparations, if we speak specifically about reparations. And few key issues appear there. And that would be, I'm just checking whether I'm over time. No, okay, sorry. So few issues are important there. One is the temporal aspects of it and how far the reparations will go back, which are the violations that will be addressed. And in this case, US is particularly unique. The only program which came close, to addressing historical grievances, which are distant from the present time, was the German Forced Labor Compensation Program and other programs that the German government implemented in lieu with what happened during the Second World War. Other than that, there is no other country that I'm aware of that has attempted reparations for events which happened a long time ago. So in that way, the US case, it's different, and probably there is no precedent out there in terms of addressing those, but hopefully it will set up a precedent, because obviously, there is a demand not only for reparations for slavery, but also reparations for colonial crimes, and so and so. So that is very important, and that's why I think, that there will be a precedent which will be sent by the prospectively, ideally, by the United States reparation program. The other two challenges is typically to define who is the victim and what is the violation and what is the harm, and then that should define and inform what's going to be the remedy. I think that's a process that every reparation program in its design goes through. The most critical component in this is also to have a very broad consultation and meaningful, not only consultative, but meaningful consultations with those who are supposed to benefit, or those who are damaged, or those who are victims, etc. So I think that's coming forward, to which extent the HR 40 as a study on reparation will allow for such a process, given that it has approximately 1 year to come up with a recommendation. That's a different thing. But I think there should be a process of consultations where all the potential beneficiaries and also other actors, as well as other stakeholders, including the government actors, will be consulted about the process. And that's the only way how you're going to arrive at a meaningful and feasible reparation program. The next thing is the challenge is that every other reparation program faced or is facing around the globe is how to come up with an appropriate legislation and how actually to push with this in terms of having it adopted. And that also involves not only the beneficiaries, not only the victims, not only those who have been harmed, but also the political factors. And that's where the difficult part is. And I think US, as any other country, will face a challenge in terms of coming at a situation where there will be a political consensus. Yes, reparations are needed, and yes, it should take this type modality and form going forward. However, one of the most critical points when it comes to reparations, apart from having a political consensus in it, I have 1 minute, thank you very much, Lisa, and I will try to wrap it up, is the financing of reparations. And that has been challenged for every single reparation around the globe. And based on the projections for the reparations for slavery in the US, the total sum which will be required is quite significant. And there is a due consideration need to be given to different financing mechanisms, either ranging from taxation, targeted taxation, maybe social bonds, maybe litigation, and so and so. But that still can be subject to a completely different discussion. I'm going to end in 1 minute just to point back, that in order all this to work, there has to be a society consensus, which will lead to a political consensus. And I think in order to arrive at the society consensus, that there is a need for a proper public outreach and informing every single citizen and every single political actors about what reparation is and why is it needed. During the congressional hearing the other day, I heard many misconceptions, particularly from the side which is not supportive of the bill, of the HR 40 bill. And I think, that shows that how much work there is needed, in order to move forward. I will stop here, and I will be happy to complement my discussion later on as we move forward with the question. Thank you.
Thank you so much, Igor, for your comments. So next we'll hear from Eduardo about his experience, generally speaking, but also with the Peruvian Truth and Reconciliation Commission.
Thank you, Lisa, and congratulations on the first panel in this speaker series. It's great to see so many wonderful colleagues in the panel and among the co-sponsor organizations. As you said, I will be discussing basically truth commissions, but bringing perhaps to the conversation some cases as they become relevant. Now, I do think that the point to start is, as Pablo mentioned, the principle, the basic principle behind the practice of truth commissions. That is the idea that victims of the worst human rights violations have a right to the truth, a right to know the facts, and a corresponding obligation of the state to investigate and reveal those facts. But of course, since facts are just an aspect of the truth, the right to the truth is quite demanding, because actually it consists in the right of the victims to learn the facts of the violations, but also learn the context, learn the responsibilities, and have recognition for the consequences of those actions. So for example, if another policeman kills an African-American man, once again, the victims have a right to know the truth, but the victims are not just the immediate family of this person who has been shot by the police, but also society. Society has also the right to know why is it that this is happening, not just the facts about what happened, but why is it that it happened? What is the context? What are the responsibilities, both personal and institutional? And what are the consequences of that, not just for the family and the direct victims, but for society at large? And I think that needs to be emphasized. The right to the truth is quite a demanding concept, really. And since it is so demanding, we shouldn't be assuming that the only way to move forward with the right to the truth is to do the creation of a truth commission. There are a variety of forms with which you could try to find the right to the truth and implement it. For example, opening state records, official archives. One of the things that we don't know about the killing of African-American men by police is that we don't even know the exact number every year. We don't know because there is no central police authority in the United States, and different institutions, the Washington Post, Human Rights Watch, etc., try to build databases about this, but nobody really knows. Nobody has that information. So opening archives to investigate and reveal trends is a form to pursue the right to the truth. Of course, criminal trials are also a way to look into the truth and to reveal facts. The problem is, of course, in a society like the US, which is so obsessed about criminal trials, in this society, criminal trials are even a form of entertainment, right? They are broadcasted massively, and people are experts on the technicalities of a criminal trial. The problem is that a criminal trial has a number of limitations, and it's a very poor substitute for a real societal dialogue about what happened and for historical lessons. So truth commissions emerge as a way not to contradict what happens in a criminal trial, but to complement that kind of action. Investigating the truth from a non-judicial angle, which is what, by the way, every human rights organization does, but doing that investigation officially in a way that is not constrained by the formalities of a criminal trial can have an important effect in revealing the truth and in giving a platform to the victims. This is probably what is so important about truth commissions. Truth commissions are a disruptive expansion of the national agenda and an equally disruptive expansion of the public sphere. They expand the national agenda because they put uncomfortable issues there, and they expand the public sphere because they bring the victims there, the persons that never appear in the public sphere, and they give them a voice. So it is potent. The cost of being that potent, the cost of being so disruptive is that truth commissions are ephemeral. They last for 2 years, 3 years, if you're lucky, perhaps 3.5 years, and then they grip the nation with their activities during that time. But at some point, they have to finish and they have to provide the nation with a report. So truth commissions require something to be effective. And I think they do require anchoring in concrete social movements. Truth commissions should not be just the brainchild of enlightened legislators or the decision of a government that wants to look good in the international sphere. right? Truth commissions should be the result of a movement where the direct victims are engaged so that the commission is anchored somewhere. And the other thing that I believe truth commissions need is certain capillarity. Truth commissions have been characterized by proposing a national narrative, a narrative that gives us as a country a new idea of why is it that we are together and what can we do together. What does it mean to be a Peruvian after the civil war with the Shining Path? What does it mean to be South African after the apartheid? Can we live together? And what truth commissions do, I think, is to provide that national narrative. But I think they lack a lot of capillarity to look into the local sphere, to look into the communities, where a lot of truth is also necessary. So anchoring in social movements is a fundamental success factor. Another one, I think, is political will, right? If a government is really not supporting a truth commission or is ready to betray its promises of transitional justice, then there is not going to be movement, honestly, right? Take, and I would like to bring two different examples here in West Africa. Take Mali and take Cote d'Ivoire. Mali created a truth commission in the middle of a very complicated internal conflict, and they persevered. In paper, it's impossible to have a truth commission in Mali. In reality, they have received over 12,000 testimonies from victims. They have open offices all over the country. They have put together persons representing all the different factions, and the commission works. Take Cote d'Ivoire. A lot of money, a lot of international visibility, conversations with a lot of important leaders, with the president of Cote d'Ivoire, and a truth commission that has all the resources to work, and it barely works. A waste of time and money and resources, right? So political will and honest political will is fundamental. So what would be my advice now that this is being discussed in the United States? Well, there are a couple of very important bills in Congress. One is, of course, the bill establishing a Truth, Racial Healing, and Transformation Commission, presented by Congresswoman Barbara Lee from California and supported by Senator Booker. And the other one was presented by Representative Haaland on establishing a Truth Commission for the experience of the Indian boarding schools. So quite similar to the Truth Commission of Canada that looked into the forced assimilation of indigenous children. The problem is that those bills have hundreds of Democratic co-sponsors and they don't have a single Republican co-sponsor. And so in those conditions, it is, I believe, dubious that the House or the Senate will force a Truth Commission, given the delicacy of the issue and perhaps the prudence or extreme prudence of some of the leadership. And it's also a question open whether the Biden-Harris administration would act in an executive manner. So if that is the issue, then the question is, where is truth breaking the dike? And I think it's happening at the local level. There are over 20 local truth commissions that have been established over 2020. Over 20. There is the Maryland Truth and Reconciliation Commission on lynching. There is the Truth and Healing Commission of California on the relationship with indigenous peoples. There is the Truth Commission of Iowa City, the Truth Commission of Carlisle, Pennsylvania. And those are the ones that have been formally established. And what I think that wave of truth commissions can do is to create the critical mass so that the national discussion on truth seeking can have the legitimacy, the grounding, and the capacity that is necessary to go forward. So I think that a truth commission for the United States, or a combination of truth commissions and other initiatives like opening archives, for example, looking into the facts, looking into the truth, and opening a constructive national dialogue is an idea whose time has come. It will happen. The question is, what is the best strategy to get there? And I do think my money is on the local truth commission movement. So I'll stop there.
Thank you, Eduardo. So next we have Sarah.
Thank you very much, Lisa. Good morning, good evening, everyone. It's good to be part of this panel discussion that examines how the US can learn from the experiences of contexts in the global South. It's a reversal of roles that have historically been dominated by countries in the global South, seen as recipients of knowledge and expertise from the global North. The ICTJ is ready and available to support TJ initiatives in the US at all levels, drawing from our extensive comparative experience. I will be sharing the Ugandan experience and seeing if there are lessons that could be useful for the US as it embarks or considers a transitional justice process. Briefly, in terms of the historical context, Uganda, like many African countries, post-colonial African countries, has had a turbulent political history characterized by civil wars, repressive rules, mostly triggered by the legacy of colonialism, weak institutions, ethnic divisions, manipulation of elections, economic and political marginalization, and the struggle to control resources. Successive attempts to address the legacies of the past in both 1971 and 1986 were half-hearted and did not yield much fruit. Whereas the 1986 Commission of Inquiry made a number of critical recommendations, including reparations for victims, the report of the commission was produced at a time where the political context had changed, and thus there was no political will to take forward these recommendations. Consequently, this was a missed opportunity to comprehensively tackle the historical grievances over the years, thus leading to more conflicts in the country. One such resulting conflict was the one initiated by the Lord's Resistance Army because of a perceived marginalization of northern Uganda. The conflict, which lasted 20 years, was characterized by some of the egregious human rights violations, including killings, rape, various forms of sexual violence, and displacement. In 2003, following the failure to bring the conflict to an end through military response, the government referred the situation in northern Uganda to the International Criminal Court, which resulted in the issuance of arrest warrants against 5 of the top LRA commanders. In February this year, 2021, the ICC convicted Dominic Ongwen, a former child soldier turned ruthless commander of the LRA, for 61 counts of war crimes and crimes against humanity. His conviction has renewed debates about transitional justice approaches in Uganda. The transitional justice process in Uganda is also underpinned by the Juba peace process in 2007, which resulted in the signing of the agreements on accountability and reconciliation, and set an overarching framework for truth, justice, and accountability. 12 years later, in 2019, the government adopted the National Transitional Justice Policy. So what have been some of the significant successes? There have been few, but the most significant is, in my view, the recognition and broad consensus that victims are entitled to reparations and redress. The delay in implementing the policy notwithstanding, it's no longer in dispute that the government must establish measures to repair the harms endured by victims of human rights violations. This, of course, is credit to the resilience of victims and also the unofficial truth and memory processes that have happened across the country in the absence of unofficial process, which have created impetus to recognize that redress for victims is a critical matter for Uganda to break ties with its past. Hello, Lisa, are you there?
Yes, you still have time. Oops. Uh-oh, it looks like maybe Sarah is frozen. Can you all hear me? Yes, okay. We'll give her a chance to rejoin. Okay, so maybe while Sarah is reconnecting, Yasmin, do you want to maybe get started, and then we'll give Sarah some time if she's able to reconnect?
Thank you, Lisa, and congratulations to you and all of the sponsors for really putting together a remarkable event. And it's wonderful to be with a number of old friends as well. In many ways, it almost seems as if this is one of those really important political moments that one has, in which you can deal with really intensely political processes of dealing with the past. And, you know, I think that's the one recognition we should have, that these processes are political, but also that you cannot do it alone. And, you know, one of the hard lessons, I think, coming from both South Africa and Sierra Leone is the fact that all you do is you put a brick in the wall of a foundation so that the next group can continue that work. And I think, as Pablo said, I mean, truth recovery is not only about individual victims and their families, but it's also about a society and how it's going to move on. And for me, one of the words that I think characterizes these processes is really dealing with the denial. Denial by either a former state about the crimes perpetrated by the state, or denial by those who have been the beneficiary of the violations and the constructs that have in fact been there for a long time. And I think in the United States, when you look at the question of racialized violence, in many ways, it's very similar to South Africa, where there was an enormous amount of denial. It's also about dealing with dehumanization and restoring the dignity of victims, and really ensuring that victims are recognized as full citizens of the state. It's a narrative about the past that needs a national conversation, but one almost has to be careful of instrumentalization by the state. In my own country, of course, and I will speak to that experience, we had 350 years of oppression based on racial discrimination, which was underpinned by law and policy. But of course, global realities like the end of the Cold War and the coming down of the Berlin Wall, as well as the fact that many banks in the US refused to continue to support the apartheid state, forced both parties to come to the negotiating table. In reality, nobody had won the war. And in a transition within the apartheid state, you had a new leader, F.W. de Klerk, come to power, and he immediately began the dismantling of some of the vestiges of the apartheid state. I was there almost from the beginning. I was very privileged to be part of the constitutional discussions and the transition. But I was one of those people who was convinced that what we needed was criminal accountability for the crimes that had been committed, given that apartheid had been declared a crime against humanity by the Security Council. And so I was absolutely shattered when I got up one morning and learned that, in fact, the liberation movements had, in fact, compromised, they capitulated on the notion of criminal accountability. And what they had agreed to was really a conditional amnesty, which was linked to this notion of truth recovery and reparations for victims. And I remember going to discuss this with my mentor, who became the first Minister of Justice. And he was quite sort of callous in the way that he said, well, you guys can stand outside and you can make a fuss about it, or you can actually think about how we can make this an accountability process. And that was a real challenge for civil society. And I think we were around 50 human rights organizations. And so when Eduardo talked about that need for a social movement, in my country, that coalition of human rights organizations actually formed that social movement. And what we did was we went around the country, we consulted with victims. And I think for many of us, lawyers who believe in criminal accountability, it was quite shattering to hear from victims that in fact, they were they trusted President Mandela so much that if he was willing to forego the need for criminal accountability, they were willing to accept that too. The only thing that victims did say is that what they wanted was to know what had happened to loved ones. So the question of the truth was really important for them. The second was, of course, the notion that they would be able to come face to face with perpetrators and in a sense be able to have this conversation about why this was happening. And in a way, what that did is it gave us the necessary tools to go in to actually navigate the legal process. And, you know, passing the law in South Africa took more than a year. And that was because of these intense discussions which were taking place. And of course, in that construct, you also had an enormous amount of traffic from Latin America, experts and practitioners who had been through processes in the Latin cone. And of course, the big question at the time is, what is the obligation of the state? And how do you deal with the political realities when it's not possible to prosecute? And at that point, truth commissions were almost seen as a substitute and not a complementary measure as we see that today. And the South African Truth Commission, in fact, actually was fairly ambitious. Not only did it have to deal with the question of truth recovery, it also had to deal with reparations, it had to deal with the investigation of violations, and of course this question of the conditional amnesty, which was really looked at as the carrot and stick approach, where the Human Rights Violations Committee would do its work, and that information would trigger really an amnesty application. And in a way, I think it's only Colombia today that may have a very similar process under the special jurisdiction for peace. For me, what was really important was, of course, the fact that we were able to create the conditions under which victims all across our country could come forward and speak. The South African Truth Commission was, of course, the first one to have public hearings. But we not only heard victims, we also heard perpetrators who had to come forward and make full disclosure about the crimes they had been implicated in. Sometimes they didn't tell the truth, and that led to enormous disappointment. But what restored the accountability of the process was the fact that the law that we drafted made it very clear that if you did not apply for amnesty, or where amnesty had been refused, then of course the law would follow its course. Now, one should remember, of course, that in my country, by 1913, Black people had been completely dispossessed of the land, and they had been taken into rural areas where they became migrants in their country of their own birth. And in fact, every facet of life was controlled by the apartheid system. And so when one looks at the significant successes of the commission, what was critical was, of course, that even though we knew about the crimes that had happened, what was really important was for this official body to turn that knowledge into an acknowledgement of the pain and suffering of victims. And that I think is quite a distinct element of the work of the Truth Commission, the notion of a public acknowledgement of the pain and suffering of the human beings. The second, of course, was that we were able to deal with the denial by the apartheid state that in fact it had set up death squads after a particular period to take out anybody who was in fact a dissenter. And in fact, this challenged the notion of why this war had been fought. And that was an important narrative to provide to the country. But we also challenged the liberation movements on the notion that in the construct of a just war, that they themselves have not committed human rights abuses. And when you look at South Africa today and many of the issues it is dealing with, you begin to recognize how important that contribution was. But when we look at this question of challenges, and I think that this is something that we learned in South Africa, which at least other commissions around the world have taken to heart, we focus primarily on what I would call civil and political rights violations, which are critical. But what we didn't deal with were what I would call the political economy of conflict, and the question of the socioeconomic dimensions of the conflict, because that's really the legacy of what we deal with today. And in fact, I think that that's the lesson that Sierra Leone learned, that you had to deal with the structural questions and also the question of how conflicts affect women and girls disproportionately. And so while we didn't tackle the gender issue sufficiently in South Africa, we certainly were able to do that in Sierra Leone. But some of the most important lessons, of course, coming from both of these processes, and I think you heard Pablo and Eduardo speak about it, this is about inclusive participation, ensuring that you take into account the voices of those who have been the most excluded. The question of building national ownership and not transplanting one process from another country and simply putting it there, because that was the temptation during the 1990s, the cookie cutter approach in any peace agreement. And I think that what we've learned from them is that in every country there are unique circumstances, and as long as we keep the four main pillars together, this can be a helpful bridge really to go forward. So when one thinks about what can be done in the US, I think that we're not building a better past in the work that we do, but what we are doing is using the past to build a better future in which we have acknowledged what has happened to people, and also we document that, because the documentation is like an insurance policy. Nobody can ever take that away from you. And if an official body does that, then of course this is something you can give back to a society, and that can be the basis for much historical, socio-economic work that will take place over many, many years, because these are processes really of a lifetime. I'll stop there. I think my time's run out.
Thank you so much, Yasmin. So Sarah, if you'd like to take your remaining 5 minutes for the lessons, that would be great. Thank you.
Thank you, and my apologies for the intermittent internet connection. We're still recovering from the internet shutdown following the elections, but kindly seek your indulgence. So just due to the limited time that I have, I'll just go through very quickly a few of our challenges and then the lessons. The prominent challenge in Uganda is that we are pursuing transitional justice in the absence of a transition. We have not had a proper break with our past. There's a continuation of human rights violations, impunity and repression. Some of the alleged perpetrators of human rights violations remain in positions of power, and therefore the ruling class is reluctant to undertake a comprehensive transitional justice process that entails reforming abusive institutions and strengthening institutions that are key to upholding the rule of law, tackling impunity and human rights. It's been made clear that the survival of the regime depends on keeping the key institutions such as the Judiciary and the Uganda Human Rights Commission weak. We've obviously had an implementation gap. As I mentioned, the agreement on accountability was signed in 2007. However, the policy was passed in 2019. For all these years, victims have not got any form of official recognition or any form of reparations due to the lack of political will, and as I mentioned before, the lack of genuine commitment to pursue transitional justice processes. The other challenge, which I believe will also tie in as a lesson, is the elite-driven top-down processes that have had very limited engagement and consultation with victims and war-affected populations, who are perceived as lacking the expertise to determine how best transitional justice processes should respond to the harms and violations that they endured. For instance, the drafting of the National Transitional Justice Policy was predominantly spearheaded by technocrats within the justice, law and order sector, with very minimal consultation with victims. The other, and I think Madame Suka has mentioned this, is the overemphasis and privileging of violations of civil and political rights, of physical abuses, while ignoring the violations of economic and socio-cultural rights. The TJ discourse in Uganda has focused predominantly on those who suffered physical abuse, while ignoring those who lived in deplorable conditions in internally displaced people's camps, who had limited access to healthcare, education, clean water, work, and sanitation, which had vastly affected their livelihoods and dignity. Therefore, it is critical that transitional justice processes take a holistic look at the types of violations. Now, when we look at what would be my advice for the US as it embarks on the TJ path, one is looking at, as I mentioned, transitional justice processes that address not only the massive human rights violations and their consequences, but also the root causes of conflict, of legacies of violence, and also the deficits in governance. And here I would like to draw from the African Transitional Justice Policy Framework, which stresses the importance of designing and implementing transitional justice initiatives using a nuanced approach that is rooted in understanding of the context, social and political dimensions, and the complex factors that have led to violence and instability. The AUTJP as well stresses the importance of looking at transitional justice as a journey in which a society confronts the different legacies, recognizing that cycles of violence often overlap and recur in contexts where the historical injustices and discrimination persists. Viewing transitional justice as a journey serves as an important reminder not to confuse transitional justice processes such as truth-seeking or reparations as an end in themselves, but as part of a long-term process to attain sustainable peace, justice, and democratic order. And then finally, it's important to have a genuine survivor-driven transitional justice process in which survivors and the most affected by harms play a prominent role in the design and implementation of the transitional justice processes. And this is not just to leave it to the political elite who get to determine the transitional justice agenda and priorities. It's key that we recognize that victims and survivors do have the experience and do have the expertise that would be useful for a credible transitional justice process. So I'll leave it at that due to time, but I'll be happy to respond to questions.
Thank you very much, Sarah. So Sally, what we've asked you to discuss is we've heard all kinds of very helpful recommendations and insights. In your experience, in particular, you did learn from other experiences. And so it would be great to hear what it looks like for a US Truth Commission process or reparation process to engage with these global experiences, and how and if it's helpful and relevant.
Well, thank you very much. Can you turn that, just turn it off? The phone just rang, of course. Okay, anyway.
We'll tell you you're on.
Okay.
We can hear you if you want to go ahead.
Yeah, I'm going to go ahead.
It's not distracting, yeah.
Okay, so, well, this has been wonderful to hear from all of you because this was the ICTJ, the International Center for Transitional Justice, was really who guided us from the beginning to the end of our Greensboro Truth and Community Reconciliation process. So let me just talk about that. Let me just sort of, because there have been so many things that people have said. I've taken lots of notes, so I will think about this more. But I just want to say that the experience of people from the South African Truth Commission, from the Peruvian Truth Commission, from the Guatemalan process that had already started in the groundwork, the actual individuals, and I'll say their names. One is Eduardo Gonzalez, and another was Lisa Magarel, who's an American who spent years in Central America. And the third really important, helpful person for us was Reverend Bongani Finka from South Africa, who was part of the truth process there. And I just want to say that the words transitional justice, I think, mean a whole lot in the global South, and but those words are not. We didn't really use those words particularly. I mean, we were clear that it was the International Center for Transitional Justice, but what really excited people in the grassroots in Greensboro, North Carolina, was the Truth and Reconciliation Commission. Mainly people knew about South Africa, and then also somewhat about Peru and other places. But that was inspirational to us because, I mean, let me just say that this was the Greensboro Massacre in 1979, where I was part of a group that saw that the Ku Klux Klan was beginning to be active again in North Carolina, and we wanted to oppose them. So we organized a anti-Klan rally and conference. And little known to us, the police got involved and actually helped basically organizing a Klan attack on us. And the Klansmen and Nazis drove in to where we were gathering. We hadn't even started our march. And they opened fire and they killed 5 of my friends. They also shot my husband in the head and arm, but he survived. He's still partially paralyzed. So it was like a real shock. It was a really horrible situation. And the newspapers, of course, the police, basically the whole community in Greensboro, certainly the white community and also large parts of the Black community just ostracized us. We were just terrible, because we also were communists at that time. And so they just put all that together and shunned us. And so we went through 3 trials, one only a partial victory, a very small partial victory in the 3rd trial. And it was just really hard. It went on for 20 years. And then we had the idea, or we started looking around at truth commissions, and people helped us, to conceptualize us and be in touch with people. And it was just an amazing process that, I mean, like Lisa Magarel, I think she moved to Greensboro for quite a while. Eduardo came down over and over again, really helped us. We were so small and isolated. We had reached out and, we had developed some friendships and connections, especially with churches, mostly Black, but also some of the white churches. But we were still so isolated. And really, I couldn't imagine that we could pull off something like a truth commission. It just seemed impossible. But Eduardo, man, I'm telling you, he was fantastic, really understood. And Lisa, and then Bongani, once we started having hearings, Bongani Finka was there over and over again to help us, flying all the way from South Africa. It's just amazing. So that's my experience. And I really do think that, well, let me just say this, that I think that there's a lot of potential for truth and reconciliation. The Canadian Truth and Reconciliation on Indian residential schooling, I was involved with that through ICTJ, went to 2 of the national hearings, the national events that they had over periods of years, and met people who from Maine in Native American women, Wabanaki women, who set up a truth commission in Maine. It was a state commission that was against the how Native children are pulled out of their home and adopted into white families, just in, you know, with no accountability of any type. And that was an amazing truth commission as well. And I think there are now a bunch of processes that are starting, and we have a really good basis to do this. And so I just want to say thank you all. I mean, you know, you all have been inspirations to us, and I just can't thank you enough. And I do feel very excited about doing that. I mean, there's been, because truth and reconciliation means a lot to people. Just here, I live in Hudson Valley. My husband and I live in Hudson Valley, and I'm very involved with Native American activism. And we have a truth process, a truth and reconciliation process with a 300-year-old Reformed church in Kingston. It's the oldest church in the county. And we have a process going on between the Native people living around here and this church that's been wonderful. It's a very local, it's not a commission, it's just a process of building community, strengthening community among us. And so I just see a tremendous potential for this work. And I'm glad to, you know, people have questions but I can't, but I just, my faith is in you all. It's really, and in the people in the US who really want to bring a more just society. And I really appreciate, Sarah, your advice to us. I took notes on that. So about how it's a journey and it's part of a long-term process. And the Greensboro process has been growing ever since we had it. Almost 20 years ago was the commission. And just to give an example, the Greensboro City Council they refused to ever say that what happened under their watch, under their police department, they refused to issue any apology. They refused to support the Truth Commission process. And just a year ago, just in the last, I don't know, 6 months or so, they have done an apology to us, the victims of the Greensboro Massacre. And it was because we were the victims of this right-wing violence that has has grown recently, as you all are aware. And they acknowledged it was in that context that they saw what happened back in Greensboro in 1979 was a big part in how that far right violence has grown in this country. So anyway, that's that. I'll leave it at there so we can get on with the discussion.
That's great, Sally. And what I hear is, yes, there is something to be learned. All right, so we are going to now open the chat. I was using it to help the panelists know their timing. I do realize we're still potentially going to run over time, and if there are panelists that because of the hour or you need to get off, please do so. But I suspect we're going to have a nice conversation here on so many issues. What I've been doing is reading the Q&A. And trying to get some general questions based on those as opposed to specifics, because I think we'll hit on some general themes. One thing that keeps coming up, I believe, is the uniqueness of how the US approach is very decentralized, that we do have some federal initiatives, as we heard, probably because of political will, less likely to move forward, although HR 40 has way more co-sponsors than it ever did before. But we see a lot of initiatives at the local level that many of us, especially who have been in the field for a long time, recognize as unique. And so how does this US experience, has it happened, or is there something to learn from, or is this the contribution that the US experience will make, and how might it potentially change the field in our understanding of how it works. So we haven't really set up a system for me having each of you speak, but if you want to just unmute yourself and comment, I'm sure that would work well for answering that first question.
If I may, Lisa, just a few comments about this, and in line with the idea, the recommendation that copying a pre-established model from elsewhere would be a big mistake. That there is a need for a reckoning with the past in the US, there is absolutely no question. I think that this is absolutely fundamental, and it is fundamental not just for a particular community, it is fundamental for the country as a whole. James Baldwin was very fond of saying that one of the main tasks of his work and the work of other people that participated in the civil rights was to dispel myths and delusions. And I think this aligns perfectly with Yasmin's commentary that part of the task of a truth commission is to confront negationism. So this is a country that has built a lot of its normative convictions around the idea of exceptionalism. And there is a lot of that exceptionalism that merits a very, very careful revision, because clearly it excluded a lot of people, and it did not exclude it only during the times of slavery. Some of the legal ramifications of segregation are still with us, not to speak about the distributive consequences of segregation, which explain the absolutely horrendous disparities across all indices of well-being between the white population and the non-whites in this country. So I think that the reckoning is absolutely essential. Having said that, however, I do think that there are particularities about the country that have to do with the magnitude, with some attitudes towards institutions. There is a sort of mistrust about the federal government, which of course has been heightened recently, but that has a long, long history. And there are also cultural dispositions that I think are important and that are very different from places in which truth commissions have operated, in which, for example, the idea of the confessional, of a certain type of exchange between truth and redemption, is completely different than it is culturally, in a broad sense, in the United States. So I think that one has not to fix on a particular recipe, but on a particular goal. What is it that we want to accomplish? The goal here, for example, is not truth discovery. It is the socialization of truth that is actually incredibly well researched in this country over time. So we should be asking ourselves, what is the most effective way of socializing those truths, of neutralizing some of the worst consequences of the legacies of segregation? And with respect to more recent events, what is the role of a judicial system in a functioning democracy in which there are still there's still a functioning judiciary, and how to complement these processes all together. Copying is a big, big mistake. I think that there's a lot that can be learned in terms of the reckoning, but I would not recommend adopting the model wholesale.
And Igor.
I mean, going back to the question about grassroots approaches and our praise, that we all have toward the grassroots approaches, there is definitely no question, that this is probably the best approach because it's the closest to the community. and it can really capture, you know, what the communities want and what they need, you know, and therefore will be most representative. However, based on observations in other locations, in other countries, there is also danger to it, you know, because the purpose of having a centralized approach, and this is the question of centralization versus decentralization of reparations or any other transitional justice mechanism, is that the fully decentralized approach might render, you know, different sort of modalities and different approaches in different locations, which in a way might discriminate based on the location. So Truth and Reconciliation Commission in one town might come up with a different solution, maybe for the same type of violation, you know, from a Truth and Reconciliation in another town, just because of the different disposition of the powers in a particular localities. Hence, it is always important, and that's what we have been advising, you know, other countries who go through this, you know, to come up with an overall framework, which would be at the more or less central level, which should provide, if nothing else, some do's and don'ts, you know, in terms of either Truth and Reconciliation or either reparations and so on and so on. So for me, you know, it is very good to have this bottom-up approach, but it is also good, you know, to have the semi-centralized approach where there would be some overarching framework in the US, ideally brought up at the federal level. And the reason why it should be also on the federal level is because the federal states has a responsibility, because it has been identified as the one who has either encouraged by law or by an inaction what was going on either during the slavery period or in the various type of various segments of violations, historical violations that happened afterward. So federal states cannot be excused from providing a framework and also supporting the grassroots initiatives. You know, so that was just a very, very brief comment on the grassroots approach versus top-down approach, and also the issue of centralization versus decentralization.
So a coexistence of the two approaches. Any of the other panelists want to address the decentralized approach in the US?
I mean, I think that it's really always important to have a grassroots approach, but at the same time, you do need a national reckoning. When you look at what the American system has reproduced, we're talking about structural legacies of discrimination, but also one that has reproduced the denial around questions of slavery and discrimination. And, you know, it's really critical to think about how did one reproduce the kind of right-wing violence that you've seen in the United States, which to some extent was really on show in January with the outcome of the elections. And so grassroots initiatives are important, but there has to be a linkage with what is happening at a central level, because this is a question of how a federal system has reproduced these kinds of structural problems. And to some extent, if it doesn't happen there, there is no real potential for conversations around change. The question of reparations, the question of legal reform, about the need for you know, discussions around the sociology of violence that has been used in the United States. I think that that kind of exceptionalism is something that one has to guard against. So without, you know, copycatting what is happening in other places, I think the question is, how do you draw a line in the sand? And what is this reckoning going to be about in a way which in fact restores the humanity of people? Because the one thing you listen to almost all of the time is the humiliation of people, the dehumanization, and dealing with that restoration of dignity is going to be quite critical in the days ahead.
Eduardo.
Thank you, Lisa. Just a word about this complementarity of approaches between building a national narrative and local narratives. This is not an idea that just emerged. It has actually happened somewhere else. And a case that I think is fascinating to me is the case of Brazil. Brazil is also a large country. It's also a federal structured country. And they created a Truth Commission a few years back to look into one specific issue, the military dictatorship that they suffered in the 60s and 70s. And what happened is that the national government established a Truth Commission. But since Brazil is a federal structure, And the social movements, to be honest, were not completely sure that the Truth Commission was going to do what it was supposed to do. They started to create their own commissions. So there were truth commissions in different states, in different cities, in universities, in unions, etc. I remember being at some point in a law school, the law school of the University of Minas Gerais, and a professor told me that the law school was going to create a truth commission. And I was scared, and I say, are you sure? I mean, why a truth commission for the law school of the University of Minas Gerais, of the state of Minas Gerais in Brazil? And he said, you know, because we want to know why our small law school gave 3 ministers of justice to a fascist dictatorship. And I think that's a very good reason. I think that the capillarity of truth-seeking in that regard is quite interesting. And what the Truth Commission did eventually was to establish agreements of cooperation with about 29 of those local commissions that emerged in different places. And that is, I think, a very interesting model. I'm not saying that that is exactly what should happen, but there are ways forward. Also, remember, in some places, truth commissions happen at the local level, and this is perhaps also the case of the US, because there is no political will at the national level, and you have to start somewhere. Right? So in Colombia, before the current Truth Commission, there were truth commissions launched by the feminist organizations, for example. In Mexico, because there is no interest by the national government and the national government has not complied with its promises, there have been a Truth Commission in the state of Oaxaca and another Truth Commission in the state of Guerrero. So would that be perhaps a model to create a more comprehensive dialogue and also to push for national action? That's the question.
That's a great example. Sarah, do you want to contribute to that?
Very briefly, and then drawing from the Ugandan context, this is a debate that we have had. We've had local processes spearheaded by civil society and religious institutions, really tackling at a local level grievances between different ethnic groups. But we've noticed that this, as we've said, due to the lack of political will, the government wants to restrict truth-seeking processes to regional level so that they do not confront the state role and state contribution to atrocities. So it's important that as we consider community level processes, which obviously address some of the peculiar experiences of that community, we cannot avoid a national process that looks at the role of state institutions, state structures in the violations and abuses that occur.
That's a very good point on accountability at the federal level. Yasmin. Oh, did you have your hand up from before? Oh, you're muted.
Sorry, I should lower my hand.
Okay, no worries. Okay, so, you know, it is an interesting, there's a lot of interesting commentary with regard to at what level it should occur, that decentralized makes sense as long as there is no political will for the centralized, but the centralized is essential for a national narrative and accounting, which leads me to ask, and again, I'm culling from all the questions, general themes, because we can't get to all of the questions, but the question of what exactly is accountability in the US, especially with so many different time periods and so many different violations. And I know, Igor, in particular with reparations, you had kind of a formula, the violation, the the way to get to a reparation program. But I think one of the struggles in the US is, where do you begin? How do you treat the far past? How do you treat current events? And there's so many up until recently with the insurrection. So what would be the advice in terms of picking the appropriate time frame that needs to be accounted for? And here again, if you want to raise your hands or unmute, we can do it that way.
Well, I will go very briefly first. I think, the time frame, when it comes to reparation, the time frame is already defined by the demand. The demand has been there in the US for quite some time, and it is obvious, what are the demands and expectations, and it starts it starts before actually the federal state was established. It starts in 1619. and it's clearly, that, there is no, that's the sort of the temporal boundaries of what is the mandate or expected as a reparation, in terms of responsibility, allocative responsibilities, or maybe liabilities about who is responsible for reparation, I think, probably it's best to trace the damage that occurred because of these violations occurred, starting from 1619, and then going forward, and then allocate the responsibility and the liability to different actors. Obviously, in a case like this, when there is a transgenerational, socioeconomical, and also other type of harm being done to a particular segment of the population, the stakeholders who will have to assume the responsibility are multiple, and perhaps it's also about the society in general. I think there has been a lot of work done in this in the US in terms of calculating, what would have happened should the slavery never happened in the US, or what should have happened if it was remedied as it was promised, following the Civil War. And where would the Black community particularly be in this particular situation if there was some kind of support of and remedy throughout the years? Instead, opposite things were happening. So what was promised immediately after the Civil War was very quickly retracted. And then additional types of violation happened, either through the prisoners leasing, or through the redlining, or through any other measures, that the white supremacist economy has perhaps imposed in a way. So going forward, I think it would be good to look at who has benefited in terms of the establishment of links between institutions, private or public institutions, and then therefore in that way allocate not necessarily the responsibility, but the liability to remedy the situation. So I will just stop here. Thanks.
Sarah.
Yes, thank you. In terms of time frame, I'll just draw briefly from a debate that has been had about to what extent do you consider reparations or redress for colonial injustices? In most of our contexts, there's been a reluctance to consider colonial injustices as part of the transitional justice process. And yet we see clear links between ongoing violations and ongoing abuses with the colonial injustices. I'll give an example. Issues of land dispossession, where communities were stripped of their right to land, which was handed to chiefs who were collaborators. Now, these communities continue to be squatters on land that is historically theirs, but the law and the system has been designed to strip them of this right. So when we're talking about reparations for colonial injustices, it may not even look at what happened in 1900 or 1900, but rather this impact that continues to affect, that has a transgenerational effect on these communities. So I would think the links are there, and that the artificial demarcations are not particularly useful.
And Yasmin.
This debate around how far you go back is one that really happens in almost every country. And the difficulty, of course, is how do you hold that conversation in a way which encapsulates those people who feel that they are the most aggrieved and who have really suffered historical injustices. And, when we look at this question of reparations, there are many different ways to deal with it. And sometimes it's a question of really beginning to document that and to hear people on that. And that acknowledgement, I think, is an important way of dealing with those issues. But I think that there's this question of the unbroken link, from these earlier periods to the kind of violence, the structural violence that one sees in a society today. And also the way in which that is manifested in different forms of discrimination. So for instance, I think there was this banker, African-American banker, who did the study on how the banks and the corporations were themselves implicated in the redlining of areas, really affecting at the heart of people's assets, this question of property and land. And so I think it's really important to look at how do you have this conversation in a society which looks at both the individual and the structural, because that's really the question around institutional reform. It's important to hold in tandem the pain and suffering of individuals, but at the same time, what a Truth Commission is really critical to is the question of documenting the patterns and the systems of discrimination and exclusion. And in that way, you can begin to deal with the question of what kind of reforms or reparations there needs to be. And remember, I mean, in the United States, you have many different examples of reparations. But when you look at the way in which those reparations programs were constructed and dealt with, it never really provided the victims with a sense of satisfaction. I think probably under 9/11, you had people paid an enormous amount of money, but there was a real sense that their views were not taken into account properly. And so I do think that it's important to find a way of going back historically, but at the same time, one needs to make the connections between what lies there in the past with what you have today. And I think that point that Sarah made, the fact that we are passing on intergenerational trauma, you see that in the United States and you see that in all of our countries. We don't have enough of a discussion around that intergenerational trauma. And also the question of how violence may take so many different forms. And I think another question which is emerging is the question of how you manage plurality and diversity, which I think is one of the biggest challenges we have in many countries around the world today, particularly in authoritarian kind of states.
Related to that point, one of the other questions relates to the fact that racial includes many different groups in the United States and many different strands of racial injustice. Many of them are running parallel. Some of them are in conversation, but often it becomes which injustice gets focused on. And are there any experiences on how to handle the complexity of multiple groups being targeted, although the overarching theme is racial violence and injustice? I don't know if anybody wants to comment to that.
May I, and unfortunately, this will be my last comment because I have to teach a class, so I have to run afterwards. But I think that Eduardo has mentioned several times the importance of capillarity. I am involved in some of the discussions around truth recovery in the US-Mexican border, for example. And of course, the phenomena in that area of the country is completely different than in some other countries in which the basic discussion is about the mistreatment, discrimination, and segregation of African Americans rather than Mexican Americans or Hispanics in general. So I think that capillarity is important in that respect. The other comment that I wanted to make, which is not unrelated to this, and that Lisa and I discussed before, I think that this is a very important moment for the majority community in this country to be in a listening mode, to not to decide what the solution is for others, but perhaps for the first time to assume the position that we have to listen, that we have to learn, that we cannot assume that we have the answers. And that the question of dignity and the issue about the intergenerational effects of discrimination has been mentioned already. That the idea that, for example, African American parents need to have the conversation with their children. I think that the majority community cannot assume that we have the answer to that. We have a lot to do because we have created the damage, but how to solve it, how to spare families the need to go through that conversation. It's very important for us now to be modest and listen to what other people have to say. And again, I am very sorry I have to run because I have to teach a class, but I want to express once again my gratitude for the invitation, my big pleasure for sharing the session with others, and my congratulations to the organizers for this absolutely great initiative. Thank you so much.
Thank you so much, Pablo. And I know some of the other panelists have to leave. There's many questions, but I had one last one. So whoever wants to stay to answer it, we heard almost across the board thank you, Pablo, the idea of participation of the beneficiaries, the survivors, the victims. So how do we assure that happens? What is the best approach to making it not, as was just commented, dominated by the elite, dominated by the majority white? How do we assure that this is inclusive and reflects those who are supposed to benefit from the process? And we can leave it there with follow-up. Yes.
I mean, I think this is such a critical issue because I think the whole point about this kind of process is that it's not only about victims, but it's also about the people who've been perpetrators perhaps, or people who've been complicit in the violations or the violence. And of course, those who are bystanders and the beneficiaries, because the big question is always, what do you want to achieve at the end of this? You want to have the basis for a shared future in which all of our children, irrespective of the kind of background they come from, are able to live together. In this context, obviously, it's really important to think about how to engage the beneficiaries in the conversation. This was the mistake in my country where, you know, it was a conversation sometimes which was really, it didn't affect the elites. And in fact, the way in which the Truth Commission hearings took place, you kind of had a dichotomy of either you were a white man who came from the security forces or you were a Black victim. And while we tried to have a number of thematic hearings, the one issue that got lost was this question of benefit and the fact that there were successive white communities who voted overwhelmingly for the former National Party and the apartheid government because they benefited from that. So this has been what I call one of the missing conversations. And when it comes to the question of reparations, but also the question of how do you build a basis for a conversation for a shared future, this is going to be critical in the United States. One of the challenges, of course, is that when the Truth Commission finished its work, and these issues came up, you know, over and over into the public discourse, white people would say, well, we've done that, we've had a commission, why don't people move on? Mm-hmm. And this is incredibly hurtful to those who have suffered violations, because the truth of the matter is, if you haven't dealt with the discrimination and the laws and policies and the kind of socialization, including culture in a society, it's impossible for those people to move on. And I think in the United States, what you're going to see is exactly that question. How do you deal with the legacy of inequality and historical injustices, which still continue to affect people today? I was listening to the discussion around access to the vaccines, and don't you find it interesting that the group that have had the least access to vaccines have been people who have come from an African-American background? And so I think it's really important to think about what are these structural impediments which allows these sorts of things to continue.
Okay, so Igor, and then I think we will conclude as we are losing our panel here. So thoughts on that? And then Sarah.
Very briefly, In order to have a meaningful engagement of survivors or victims or beneficiaries, whatever we want to name them in different contexts, it is important that they're involved throughout the process. So it's not only about what do you need, it's also about how do you need it and why do you need it. So there has to be an active discussion throughout the entire process, from the design phase when the policy is designed, through the process, and also down to the remedies. Just very quickly, one pilot model that we are currently, the organizations we are currently working, the Global Survivors Fund is trying to implement, is a process of co-creations, where survivors are directly participating in the design of what's supposed to be an interim reparative measure for them. So these engagements where they're engaging in an informed way throughout the stages of the process is critical, and it's absolutely important in order to have a meaningful reparations or any other process delivery. Thank you.
Thank
you.
So
we'll conclude with Sarah. Yes.
Very briefly, I think key to participation is consultations. Consultations with affected communities and victims will highlight what are those structural impediments that may limit their meaningful participation in these processes, but also determine what priorities should be addressed by the transitional justice processes. And key to this is working with grassroots organizations that have been in existence, that have worked with groups and survivors, that have been doing this work for years, but have not probably got the visibility or not recognized or even not packaged it as transitional justice, but it is transitional justice. So these provide useful insights on how to make these processes inclusive and meaningful to those who should benefit from them and other key stakeholders. Thank you.
Thank you so much. I have about 10 other questions I could be asking you. Obviously, the intent of this series is to continue this dialogue, which often, as especially those of us who participate in panels, we wish we had a forum to continue the dialogue. And I'm excited to say that that's the intent of this series. Our next panel is March 24th, looking at how to build collaborative models, which links to my last question. We're also looking at next year already to design particular panels to feature some of the initiatives in the US and to talk about some of the themes related to truth commissions and reparations. And we didn't do a lot on criminal justice, but we hope to do that actually in October. So please stay tuned. Anyone who has registered for this will be automatically sent the invitation. Co-sponsors will continue to raise awareness, and we just got another co-sponsor as we were on the call. So that's how this works, and it's really meant to be collaborative, working together not only with scholars who started the conversation, but the practitioners, but also our friends from all parts of the world who have this knowledge and can guide and share and contribute to the US version of transitional justice. So I want to conclude there and thank all my panelists for your generosity of time, for joining us in this unique online scenario. And I know there's a lot of questions that were not answered, and I apologize, but hopefully we will continue to answer many of those questions as we continue to organize panels. Again, if you want to get involved, you can reach out to me directly if you're an institution that wants to co-sponsor. So thank you again, everyone. And best of luck with your work, and I look forward to staying in touch. So take care, everyone.
Thank you. Bye.